If this video helped reduce confusion or brought clarity to a stressful topic, take a moment to like it and share it with someone who may be feeling scared right now. Misinformation spreads fast, but accurate information protects people. If you want calm, fact-based updates instead of panic-driven headlines, consider subscribing so you don't miss future videos. And let me ask you this, what immigration rumor or headline has worried you the most lately? Drop it in the comments. Your questions help shape what we cover next. A new immigration law? Why panic is spreading faster than facts? Right now, across social media, one sentence is spreading faster than the truth. A new immigration law has been approved. For millions of immigrants living in the United States, those words alone are enough to trigger fear, panic, and sleepless nights. Videos and posts claim deportations are already happening, that green card holders are suddenly at risk, and that a single mistake from years ago can now destroy everything overnight. The way this information is being framed makes it sound final, sudden, and unavoidable. But almost no one is stopping to ask the most important question. Is this actually true? Immigration is not just paperwork. It is your job, your home, your children, and the life you have spent years building. When headlines suggest all of that could disappear instantly, fear takes control before facts have a chance to catch up. This video is not here to add to that fear. It is here to slow everything down, to strip away exaggeration, and to replace confusion with clarity. We are not going to speculate. We are not going to dramatize. Instead, we are going to explain what is really happening, what is not happening, and why understanding the difference matters more now than ever. Because in moments like this, accurate information is not just helpful, it is protective. What this video is, and why misinformation is the real danger. Before going any further, it is critical to set clear expectations. This video is not a warning designed to scare you into action. It is not a reaction to viral clips, and it is not legal advice. What you are hearing is a fact-based explanation of a proposed immigration bill that is being widely misunderstood online. Right now, fear is spreading not because the law has changed, but because information is being distorted. Short videos, dramatic headlines, and emotional commentary are skipping over key details and jumping straight to worst-case conclusions. That kind of panic does real harm. Immigration law does not change overnight. It moves through a defined process with multiple stages, public debate, and built-in delays. Understanding that process is the first step toward regaining control when fear is being amplified for clicks. This is why slowing down matters. When people believe deportations are already happening or that their status is suddenly at risk, they make rushed decisions, canceling travel, delaying applications, or avoiding legal help when they actually need it. The goal here is clarity. We will explain what the bill actually is, where it truly stands in the lawmaking process, and what applies right now, not what might happen someday. Because panic based on incorrect assumptions is far more dangerous than the bill itself. And once you understand the facts, much of the fear begins to lose its grip. What H.R. 875 really is, and why a bill is not a law. To understand why so much fear is misplaced right now, we need to slow down and look at the bill everyone is talking about, H.R. 875. First, let's be absolutely clear. H.R. 875 is not a rule, it is not a regulation, and it is not a law. It is a proposed piece of federal legislation introduced in early 2025, just like thousands of other bills that are introduced during every session of Congress. At this stage, H.R. 875 exists only on paper. A bill has no legal force. It cannot be enforced. It does not change anyone's immigration status. It does not cancel visas, revoke green cards, or trigger deportations. None of that can happen unless a bill completes the entire legislative process. Bills are introduced for many reasons. Sometimes they are meant to test political ideas. Sometimes they respond to public pressure. Sometimes they are symbolic. Introduction alone changes nothing for immigrants living their lives today. H.R. 875 has gained attention because of what it could do if it ever became law, not because of what it is doing now, and that distinction is critical. Skipping this context and treating a proposal as if it were already policy is how misinformation spreads. It creates fear based on outcomes that may never happen. Right now, H.R. 875 is simply one proposal among many. No one's legal rights have changed because of it. Passed the House doesn't mean the law has changed. One of the most misleading claims spreading online right now is this: the bill passed, so the law has changed. That statement leaves out nearly everything that actually matters. Yes, H.R. 875 did pass the U.S. House of Representatives on June 26, 2025. That fact is real. But passing the House is not the finish line. It is not even close. The U.S. legislative process is intentionally slow and layered. After passing the House, a bill must move to the Senate, where it is typically assigned to a specialized committee for review. In this case, H.R. 875 is currently under review by the Senate Judiciary Committee, the body responsible for immigration and constitutional issues. This stage can take months. Sometimes it takes longer, and sometimes the bill never leaves committee at all. Here's the most important point to understand clearly. The Senate has not voted on H.R. 875. Because of that, the bill has not passed both chambers of Congress. Because it has not passed both chambers, it has not been sent to the president. And because it has not been signed by the president, it is not law. That means nothing has changed. There are no new immigration rules in effect, no new grounds for deportation, no new admissibility standards. Treating House passage as final approval is how fear replaces facts, and why clarity matters right now. Why immigration law does not change overnight. One reason misinformation spreads so easily is because many people don't understand how immigration law actually changes. Headlines make it sound instant. Social media makes it sound secret. But the reality is very different. Immigration law in the United States does not change quietly, suddenly, or without notice. When real changes are coming, they move through a long, visible process. There are committee hearings, public debates, amendments, expert testimony, and extensive coverage from legal organizations and advocacy groups. Nothing happens in the dark. That process has not happened here, because H.R. 875 is not law. If a bill were truly about to change immigration rules, immigration attorneys across the country would already be issuing formal guidance. Government agencies would be preparing updates. Official notices would be published. None of that is happening right now. Instead, what we are seeing is something far more dangerous: people reacting to incomplete information. Fear-based videos skip over the process entirely and jump straight to the worst possible outcome, as if proposals automatically become policy. They do not. Believing that immigration law has already changed can push people into unnecessary panic. Some cancel international travel. Others delay applications they are eligible for. Some avoid legal help out of fear, even though accurate advice could protect them. Understanding how slowly and publicly laws actually move is not about ignoring risk. It is about putting risk in the right place. And right now, the biggest risk is reacting to something that does not yet exist. If H.R. 875 became law, what would actually change? Now that we are clear about what H.R. 875 is not, it's time to address the question many people are quietly asking. If this bill ever became law, what would it actually change? This is where the concern is real, but often taken out of context. Under the proposal, H.R. 875 would significantly change how DUI-related conduct is treated under U.S. immigration law. Certain DUI offenses could become independent grounds of inadmissibility. In practical terms, that means a non-citizen could be denied a visa, denied entry at the border, or refused re-entry after travel based solely on a DUI. That would be a major shift from how immigration law generally works today. Under current law, a single alcohol-related DUI without aggravating factors is usually not automatically disqualifying. The bill would also expand grounds of deportability. Immigration authorities could initiate removal proceedings against non-citizens with DUI histories, even if the offense occurred years ago. What makes this proposal especially serious is its scope. The language is broad. Consequences would not be limited to felonies or repeat offenders. Even misdemeanor DUIs could trigger immigration problems. This is why immigration professionals are paying attention, not because the law has changed, but because if it ever does, the impact could be wide-reaching and deeply personal. Why the scope of H.R. 875 is raising serious red flags. What makes H.R. 875 especially alarming to immigration professionals is not just what it targets, but how broadly it is written. Under this proposal, immigration consequences would not be limited to serious or repeat DUI offenders. The language of the bill extends to misdemeanor DUIs, and in some situations even to cases without a formal criminal conviction. That is a critical shift. Under H.R. 875, admissions of conduct could matter as much as court outcomes. Statements made during visa interviews, border inspections, or immigration filings could potentially be used to trigger immigration consequences. In other words, a person could face serious risk not because of a judge's ruling, but because of how a past incident is described or documented. This raises serious concerns because immigration processes already place heavy pressure on applicants to be honest and forthcoming. Under the proposed framework, that honesty could carry consequences that did not exist at the time of the original incident. The bill also does not clearly limit how far back immigration authorities could look. That means a DUI from many years ago, one a person believed was resolved, could suddenly resurface. For many immigrants, this uncertainty is deeply destabilizing. It challenges the assumption that people can move on from past mistakes after completing their sentence and rebuilding their lives. This is why H.R. 875 is being watched closely, not because it is law, but because if enacted, it could dramatically reshape how past conduct is treated without nuance or flexibility. When judges lose discretion, context disappears. One of the deepest concerns immigration professionals have about H.R. 875 is not only who it targets, but how it removes human judgment from the process. Under current immigration law, DUI-related cases are evaluated with context. Judges and officers can consider the full picture: what happened, how long ago it occurred, whether anyone was harmed, and what the individual has done since. Rehabilitation matters, family ties matter, time matters. H.R. 875 moves sharply away from that approach. Under the proposal, immigration judges would have very limited discretion. Their ability to weigh rehabilitation, years of lawful residence, U.S. citizen children, steady employment, or community contributions would be severely restricted. Decisions would be driven far more by rigid categories than by individual circumstances. This shift is what alarms many legal experts. Immigration consequences are already severe. Removal can mean permanent separation from family, loss of livelihood, and exile from a country someone has called home for decades. Taking away judicial flexibility makes those outcomes more automatic and less fair. There is also a proportionality problem. For U.S. citizens, a DUI usually results in fines, license suspension, or classes. Under H.R. 875, the same offense could lead to permanent removal for a non-citizen, even if no one was harmed. This is not just a legal debate. It is a question about whether immigration law should allow room for judgment, mercy, and real-life complexity, or operate without them. The retroactivity problem. When the past comes back to judge you. One of the most unsettling aspects of H.R. 875 is the question of retroactivity, whether past DUI incidents could be used to trigger immigration consequences years later under new rules. For many immigrants, this is where fear becomes deeply personal. Under current law, people reasonably believe that once a case is resolved, after fines are paid, classes are completed, and years pass without further issues, that chapter is closed. H.R. 875 challenges that expectation. The language of the proposal appears to allow immigration authorities to consider DUI-related conduct from the past, even if that conduct occurred at a time when it did not carry immigration consequences. In practical terms, this means a mistake made years ago could suddenly take on new meaning under a different legal framework. This creates profound uncertainty. People who have rebuilt their lives, supported families, maintained lawful status, and contributed to their communities could find themselves facing consequences they had no way to anticipate at the time of the incident. From a legal perspective, this raises serious fairness concerns. Laws typically aim to provide predictability, allowing people to understand the consequences of their actions when those actions occur. Retroactive application undermines that principle. This is why immigration attorneys are watching H.R. 875 so closely. The concern is not about encouraging bad behavior. It is about whether the rules of the game can change after the fact, and who pays the price when they do. How DUIs are treated under current immigration law. To understand why H.R. 875 feels so drastic to immigration professionals, it's essential to understand how DUI cases are handled under current U.S. immigration law. Right now, a simple alcohol-related DUI is generally not an automatic ground for deportation or inadmissibility. In most cases, a single DUI, without aggravating factors, does not by itself make a non-citizen removable or bar them from immigration benefits. This is a critical distinction. Immigration law today looks beyond the label of the offense. Officers and judges evaluate context. They consider intent, harm, patterns of behavior, and time. A mistake made once, years ago, is treated very differently from repeated or dangerous conduct. That does not mean DUIs are harmless. They can create serious immigration problems in specific situations. Multiple DUI convictions may raise concerns about public safety or alcohol dependency. Drug-related DUIs are treated far more harshly. DUIs involving injury, property damage, reckless driving, or children in the vehicle significantly increase risk. DUIs can also affect naturalization, where applicants must demonstrate good moral character. Green card holders traveling internationally may face increased scrutiny upon re-entry, and undocumented immigrants often face immigration consequences after DUI arrests through local law enforcement contact. But the key point remains. Under current law, cases are evaluated individually. Context matters, discretion exists, and that is precisely what H.R. 875 threatens to remove. A fundamental shift in how immigration law would judge people. What truly sets H.R. 875 apart from existing immigration law is not just the penalties it proposes, but the philosophy behind it. For decades, immigration law has operated on the principle of individualized evaluation. Judges and officers are trained to look at the full human story, not just what happened, but why it happened, how long ago it occurred, and what the person has done since. This approach recognizes that people are more than a single mistake. H.R. 875 represents a sharp departure from that tradition. Under the proposal, DUI-related conduct would be treated more like serious violent crimes, with rigid consequences triggered by defined categories rather than careful analysis. The emphasis shifts away from rehabilitation and toward automatic outcomes. This change matters because immigration penalties are not minor. Deportation is not a temporary punishment. It is permanent separation from family, loss of home, and removal from a country where someone may have lived for most of their adult life. Many legal experts argue that justice requires proportionality. When immigration law removes flexibility, the punishment can become wildly disproportionate to the offense, especially when compared to how the same conduct is treated for U.S. citizens. H.R. 875 raises fundamental questions. Should immigration law prioritize efficiency over fairness? Should one past mistake outweigh decades of lawful residence and contribution? And should human judgment be replaced by rigid formulas in cases with life-altering consequences? These are not abstract concerns. They are why professionals across the immigration field are paying close attention, even before the bill becomes law, when the same mistake leads to very different consequences. One of the most controversial aspects of H.R. 875 is the imbalance it would create between how the law treats U.S. citizens and how it treats non-citizens for the same conduct. Under the criminal justice system, a DUI for a U.S. citizen typically results in fines, license suspension, mandatory classes, probation, or short-term incarceration. The punishment is serious, but it is limited and finite. Once the sentence is completed, the case is closed. Under H.R. 875, the consequences for non-citizens could be dramatically different. The same DUI, even without injury, even as a misdemeanor, could trigger permanent immigration consequences. Deportation is not a temporary penalty. It can mean lifetime separation from family, loss of career, and removal from the only home someone has known for decades. This disparity is what many legal experts find deeply troubling. The punishment effectively becomes exponentially harsher based solely on immigration status, not on the severity of the offense. The impact extends beyond the individual. U.S. citizen spouses, children, and entire families could face separation and hardship as a result of a single incident. Communities lose workers, caregivers, and parents. This raises fundamental questions about fairness and proportionality. Should immigration status alone determine whether a mistake results in a temporary setback or permanent exile? Should immigration enforcement impose penalties far more severe than the criminal system itself? These concerns are central to why H.R. 875 has sparked such strong reactions even before it has become law. Don't panic, but don't ignore this either. With so much alarming content circulating online, it's important to reset the focus to what actually matters right now. First, and most importantly, H.R. 875 is not law. No immigration rules have changed. Your current legal rights, protections, and obligations remain governed by existing immigration law. Panic-driven decisions made today will not protect you from something that does not yet exist. At the same time, this moment should not be ignored. Periods like this are an opportunity to be proactive in a calm and responsible way. If you have any criminal history, and including a past DUI, it may be wise to consult an experienced immigration attorney, not because you are in immediate danger, but because understanding your situation under current law puts you back in control. For lawful permanent residents, international travel deserves special attention. Re-entry into the United States is often where immigration issues surface. Getting advice before traveling can prevent unnecessary risk. For those eligible for U.S. citizenship, naturalization can offer the strongest long-term protection during times of legal uncertainty. But this is a decision that should be made carefully and with legal guidance, not fear. If you are currently facing DUI charges, coordination between a criminal defense attorney and an immigration attorney is critical. Small details can carry major immigration consequences. The key message is simple: preparation protects you. Panic does not. Staying grounded, facts, sources, and long-term protection. As we bring everything together, the most important message is this: you are not powerless, and nothing has changed overnight. H.R. 875 is still a proposed bill. It is not law. Despite what social media headlines suggest, it has no legal effect today. It has not passed the Senate. It has not been signed by the President. Until every step of that process happens, current immigration law remains fully in place. That said, staying informed matters, but where you get your information matters just as much. Viral videos are designed to trigger emotion, not understanding. Headlines are often written to maximize clicks, not accuracy. The safest way to track real developments is through official and verifiable sources. The U.S. Congress website shows the actual status of bills in real time. USCIS remains the authoritative source for current immigration rules, benefits, and procedures. Professional immigration organizations and licensed attorneys play a critical role in translating complex developments into practical guidance. If H.R. 875 advances, there will be hearings, amendments, and public debate. Real changes do not happen quietly. Most proposed bills never become law. Many stall, change significantly, or disappear entirely in the Senate. The strongest protection during times of uncertainty is preparation, not panic. Rely on credible sources, seek qualified legal advice when needed, and remember, informed, calm decisions protect your future far more effectively than fear ever could.